Hello, everyone, and welcome to the Jeffrey Epstein Show. I'm your host, Bobbycapucci, and this is a morning update. Last night, we were talking about the decision by the 11th Circuit Court of Appeals to deny Courtney Wild's motion that the federal government was in the wrong for not letting her know and the other survivors know about the immunity deal that they gave to their buddy Jeffrey Epstein. Now, any normal thinking person would take a look at this case and the circumstances and the facts that surround it and say to themselves, this is a slam dunk. There's no way these judges are going to side with Jeffrey Epstein's people on this one. Well, when you have a two-tier justice system that is filled with loopholes for the rich to navigate, this is the end result, folks. This is what happens when you have a two-tier justice system that says the rest of us should eat cake while these guys get off on the most horrendous crimes in the history of the world. Now, not all of the judges were on board. 2 of the 3 judges sided with the government, shocker, but the 3rd judge penned a scathing dissent letter about the ruling. So today we're going to get a little bit more in the weeds about the ruling, and we're going to read an article from Law and Crime. And Law and Crime always does a really good job of putting things in context when it comes to these sorts of situations. And like I always say, I am certainly not a lawyer. I'm not, I don't know how to navigate the legal system. I've never even been in handcuffs in my life. So I really don't know how the system works when you get into the nuts and bolts of it, right? What happens in the courtroom, the loopholes. I don't have that sort of knowledge. So whenever we can add context from people that do, like Colin Kalmbacher here at Law and Crime, it's definitely important to add that to the catalog. So we're going to add some more context to the whole story today, and we're going to see what Colin Kalmbacher and Law and Crime has to say about this whole entire sordid ordeal. So like I said, this article is from Law and Crime. The author is Colin Kalmbacher, and the headline is, Judge pens scathing dissent blasting federal court for ruling against Jeffrey Epstein survivors. A federal court sent a clear message to survivors of dead pedophile Jeffrey Epstein, which is best summarized as follows. Sorry, but the law says you don't really matter. Wow, that's pretty powerful stuff in the opening statement, right? The first paragraph basically laying it out on the line, what we've all been talking about for months and months and years for some of us, that the victims and the survivors of Jeffrey Epstein, in the eyes of the court, they don't matter. They're just collateral damage. And how many times are we going to see Jeffrey Epstein's people, Jeffrey Epstein himself, etc., be able to skate through justice because of their ties, because of their connections, because of their power, because their lawyers know how to play the game and navigate the two-tier justice system? How long are we going to see that before we all stand up at the same time and say enough is enough? In a 2-to-1 opinion issued by the U.S. Court of Appeals for the 11th Circuit Court on Tuesday, survivor Courtney Wild was denied the opportunity to challenge the government's handling of a controversial sweetheart deal gifted to Epstein and several of his alleged child sex predator co-conspirators by the U.S. Attorney's Office for the Southern District of Florida in 2007. I mean, how did the 2 judges that ruled against Courtney Wild and the survivors, and basically against the rule of law, how do they look at themselves in the mirror? How do they look at themselves at night? Because anyone with half a brain understands how terrible of a decision this was, and even their colleague that was sitting with them understands how terrible of a decision this was. And again, I don't mean to harp on it. I'm certainly not an ageist by any means, but a 90-year-old man has no business sitting on the Court of Appeals, okay? 90 years old? Retire, buddy. Pack it in. Despite our sympathy for Miss Wild and others like her who suffered unspeakable horror at Epstein's hands, only to be left in the dark, and so it seems affirmatively misled by government lawyers, we find ourselves constrained to deny her petition. The ruling notes, it's not a result we like, but it's the result we think the law requires. Well, what does that tell you? Okay, what does that tell you? The law is effed, okay? The justice system, effed. All of it is effed. It's time for a reboot, okay? Control, Alt, delete this MFer because it's not working. The operating system is jacked, okay? Enough is enough. It's time to revisit what our justice system is and what it's supposed to be, and it's time to really search for justice within it instead of finding ways to keep your friends out of trouble. And again, that's why these laws are written the way they are by their friends in Congress and the Senate. Oh yeah, let's make sure we have these laws written so that we know that if we ever get in trouble, we have some loopholes to get ourselves out of it. I'm tired of it. I'm sick of it, and it's both sides of the aisle that play this game. All right? Save the partisanship, save the tribalism. It's both sides of the aisle that are at fault here. And unless we get away from the whole tribalism, your team, my team, we're never going to be able to hold these people to account. All right? So shelve all of your political biases, shelve all of your I hate this person because he's R or D, and man up. It's time to get focused on what really matters. And what really matters is bringing these people to justice, no matter who they are, no matter who they represent, and no matter what side of the aisle they sit on. And if the justice system and these judges don't do the right thing, then it is up to us as the populace, as the people, the citizenry, to remove them. The scathing dissent, which is as long as the opinion itself, from U.S. Circuit Judge Frank M. Hall, tears into the majority of its novel interpretation that Crime Victims' Rights Act of 2004 does not apply unless and until a formal indictment is filed in a court. Yeah, it's just another loophole. It's just another loophole. They know that the government had the goods on Epstein. These judges have access to all of that shit. And instead they chose to ignore it. Instead they chose to make this weak-ass, limp-wristed interpretation of the law. What a bunch of gross, disgusting excuses for human beings. Hull explains that the plain text of the CVRA actually does not contain any sort of limiting language that negates or otherwise conditions the rights of victims based on whether or not an indictment or court proceeding is ever commenced. The judge tidily notes, in fact, the CVRA's venue provision in 3771D expressly provides that, if no prosecution is underway, the victims can file suit to assert their subsection A rights in the district court in the district in which the crime occurred. In filing this lawsuit back in 2008, the petitioner crime victims did what the CVRA expressly authorized them to do. And of course, the octogenarian on the bench and the Harvard Law School graduate decided that their interpretation of the law is more important than actually what the law says, like usual. These people, these judges, they are completely and utterly corrupt with power. Hull also rubbishes the ruling for using florid language in the place of justice for Epstein's victims. She brutally mocks the majority's use of sad-sounding floral prose as little more than reptiles lament. Wow. The majority also dresses up its flawed statutory analysis with the rhetorical flourish using language like scandalous, national disgrace, and the sad details of the shameful story, while also expressing sincere empathy for the victims. The majority confesses that it isn't lost on us that our decision leaves petitioner and others like her largely empty-handed, and we sincerely regret that. In addition to ruminating in sincere regret and sympathy, we, as federal judges, should also enforce the plain text of the CVRA, which we are bound to do, and ensure that these crime victims have the CVRA rights that Congress has granted them. And what I will say about this dissenting letter and how viciously she is dissenting, the other judge in the case, what it does, it really gives Bradley Edwards and the lawyers another route to take it higher, right? To convene the whole entire 11th Circuit and get a full ruling on this, because there's more here, and we can't let a 90-year-old man who probably, look, I'm not trying to be an asshole here, okay? He probably doesn't have all of his faculties still, 90 years old? Come on. And a Harvard law grad who knows if he ever benefited from Jeffrey Epstein's money? Who the hell knows? These Harvard guys, I don't trust any of them at this point. So this is just crazy. This whole entire ruling is crazy. And the one good fact out of it, though, is that the third judge, Judge Hall, has dissented, and so viciously, because it's going to bring forward the convening of the full panel of the 11th Circuit Court of Appeals to hear this now. The majority's new blanket restriction eviscerates crime victims' CVRA rights and makes the Epstein case a poster child for an entirely different justice system for crime victims of wealthy defendants, Hull somberly warns. Yo, this Judge Hull is becoming one of my favorite people on the planet. She's saying right here that there's a two-tier justice system, and it's gross, it's a miscarriage of justice, and she'll have no part of it. This judge right here gets it. This is the kind of judge that we need sitting on the bench. A judge that looks at the law for what it is and protects those that she is supposed to protect. And that doesn't mean the rich pedophiles, okay? That means the people who were victimized by these rich pedophiles and then came out on the other end stronger as survivors and with the courage to stand up and say, these people did harm to me. And these other two smarmy ass, disgusting ass judges can't see that? The True Anon podcast, which began as a left-wing crime podcast dedicated to La Affaire Epstein, offered the following upshot of the Atlanta, Georgia-based court's ruling. This means that everybody even remotely involved with Epstein's massive child sex trafficking operation in Florida is immune from prosecution. This means pilots, Ghislaine, his demonic harem, everyone. Well, that may be the case, right? But this case is not just based in Florida. All right, what everyone needs to understand is that the federal government, when they wield power and they go after you, it's not just in one jurisdiction. Jeffrey Epstein's crimes were committed over state lines. They were interstate crimes. There was money laundering crimes. There is a whole nother aspect to this case. So I'm not too familiar with the True Anon podcast, to be honest with you, but I think their assertion here, it falls a little flat. And while that might, the battle might be an uphill battle in Florida as in regards to the immunity deal, the rest of the country, in New York, Virgin Islands, New Mexico, etc., it's game on still. Courtney Wild is one of dozens of underage women, girls really, the court concedes, who were preyed on and trafficked by Epstein and his friends as part of the global elite child sex ring uncovered by the Federal Bureau of Investigations in the early 2000s. Federal prosecutors, however, for reasons unknown but widely presumed to be related to Epstein's alleged status as an intelligence asset. I mean, really? Now we have we have the legacy media talking about it now, folks, okay? So all of those people that told you were crazy when we first started this case and we first started following the breadcrumbs that led us to the fact that he was an intelligence asset, all of those people that mocked you and said you were crazy because they didn't see it on CNN or MSNBC or Fox, well, go give them the bird, okay? Because once again, they're late to the party. Once again, they're a part of the problem. Quickly dropped the ball in most of the potential charges. Epstein pleaded guilty to 2 state prostitution offenses in exchange for all of his unnamed co-conspirators receiving an unprecedented and sweeping grant of immunity from federal prosecution. And we've discussed this as well. Usually, the only people that get this sort of plea deal are your family members, right? People that are really close to you if you're caught up in something like this. But if you're Jeffrey Epstein and you're navigating the 2-tier justice system with Alan, I kept my underpants on Dershowitz as the head honcho in your all-star court team, well, this is the result. This is the result. You get sweeping immunity for all of your co-conspirators. You only do 13 months. Isn't life great if you're rich? Meanwhile, don't get busted for so-called illegal bookmaking. Don't get busted for that because they're going to drop 103 counts of RICO on you, hoping that only one sticks. And then, even if you're 70 years old, they're going to send you to prison for 9 years because you're such a threat to society because of your illegal bookmaking operation that you have to go and do 9 years. But Jeffrey Epstein? 13 months for a child sex trafficking ring, for rape, for money laundering, for every count under RICO you can imagine. This guy skates, while normal people who are just trying to make ends meet maybe get involved in a bookmaking operation. Oh, God forbid they're booking sports. How horrible. And they get 9 years? 9 years. Because the RICO count says they had a leadership role. Oh, and did I mention their last name ends in a vowel? So if you're Italian and you're involved in a bookmaking operation, automatically you're part of the mafia. But Jeffrey Epstein? Bah, Come on, no big deal. Stop. Jeffrey Epstein's rich. He gives money to charity. He couldn't be involved in any of this. You're crazy. Yeah, well, guess what? Who's crazy now? All right? This is a far-reaching crime that goes to the very top of society. And anybody who is not paying attention and anybody who's saying differently, well, they're part of the problem. Epstein himself managed to obtain palatial treatment from law enforcement while serving a 13-month stint in prison with work release. The survivors of the sex trafficking ring, on the other hand, were kept in the dark and lied to by those same federal prosecutors. I mean, if that doesn't enrage you, I don't know what will. These are the same prosecutors that kept the survivors in the dark, that gave Jeffrey Epstein his little palatial deal, his nice little walk-in-the-park deal. How is any of that okay? How are these prosecutors not under the microscope? The court's majority opinion notes, emphasis in original, and to be clear, the government's efforts seem to have graduated from passive non-disclosure to, or at least close to, active misrepresentation. In January 2008, for example, approximately 4 months after finalizing and executing the non-prosecution agreement, the government sent a letter to Wild stating that Epstein's case was currently under investigation, explaining that this can be a lengthy process, and requesting her continued patience while it conducted a thorough investigation. The government sent an identical letter to another victim in May 2008, some 8 months after inking the NPA. So, what more does the court need? It's obvious the government was in the wrong here. It's obvious the government screwed up. And it's obvious that the court refuses to acknowledge that. If secrecy was the goal, it appears to have been achieved. There is no indication that any of Epstein's survivors were informed about the NPA or his state charges until after he pleaded guilty, the ruling continues. On the day that Epstein entered his guilty plea in June 2008, some, but by no means all, victims were notified that the federal investigation of Epstein had concluded. Right? How is that not enough for the court to overturn the immunity deal? They're saying right here in the ruling that the prosecution was in the wrong. But yet, they still rule in their favor? Typical government nonsense. Wild was one of those who learned about Epstein's white-glove treatment by the George W. Bush Department of Justice well after the case was settled. She sued in July 2008 on the theory that her rights under the CVRA were violated by the DOJ's generous deal. Specifically, Wild alleged that her rights and the rights of Epstein's other survivors to confer with attorney for the government in the case and to be treated with fairness and with respect for their dignity and privacy were tossed to the wayside. The 11th Circuit majority's opinion throws up its hands. Rights under the CVA do not attach until criminal proceedings have been initiated against the defendant either by complaint, information, or indictment, the ruling states. Because the government never filed charges or otherwise commenced criminal proceedings against Epstein, the CVRA was never triggered. In other words, they knew the loopholes and they utilized the loopholes. And now, because those loopholes were navigated, you're SOL. Well, I don't accept that, and neither should you. Anyone who expects the rule of law to be upheld should not accept this sort of scumbaggery. Fix these loopholes and fix them now. Hall's dissent adamantly disagrees with that reading of the statute. The majority concludes the CVRA was never triggered at all, even though the U.S. Attorney's Office prepared a 53-page indictment against Epstein, but later secretly entered into a plea deal granting federal immunity to Epstein and his co-conspirators, Hall recounts. According to the majority, because the office cleverly entered into a sweetheart plea deal with Epstein pre-charge and never filed the indictment, the victims never had any CVRA rights in the first place. Again, all because I kept my underpants on Dershowitz, knows how to navigate the loopholes. All because his buddies were the ones who wrote the laws. And if you don't think he had any access to them while they were writing the laws, you're wrong. Of course he did. While decidedly full of invective and scorn for the majority's use of purple prose as a poor stand-in for affirming survivors' rights in federal law, most of the dissent contents itself to dissect the legalistic tricks used in the ruling to effectively rewrite the statute at issue. This is exactly what I'm talking about. This is putting the two-tier justice system on display for you all to see. Okay? This is what I've been railing about forever since this podcast has started. You or I would never be able to initiate these loopholes. You or I, our lawyers would probably not even know about them because we can't afford the type of lawyers that know how to navigate the back room, that can walk into a senator's office and sit down with a senator. We don't have that kind of money. We don't have that kind of power. But if you're Jeffrey Epstein and you've made that money illegally and you've made that money with your sex trafficking ring and your money laundering, game on. Game on. The system's yours. The world's your oyster, Jeffrey Epstein. The rest of us should just eat cake. So how in the holy name of plain text does the majority add such substantive and temporal restrictions on the victim's rights to confer and be treated fairly and hold that victims have no CVRA rights until after the government files an indictment and commences proceedings? Judge Hull asks before answering. The majority hacks away at the plain text. Yeah, look, I'll tell you what, I really can't wait to see the full 11th Court of Appeals impaneled and getting this case, because I have a funny feeling that we're going to have a different result. You see how fiery this dissent was by Judge Hull, somebody that actually gets it, who knows that these guys are gaming the system. And the fact that Newsom and the 90-year-old lawyer guy are letting them game the system like this, it should not go unchecked. It should not go unchallenged, and these people should be put on blast. Judges aren't above the law. Right? Judges are just normal people. They got a regular job just like the rest of us. They might be the word of the law inside of that courtroom, but that doesn't mean they're above reproach. That doesn't mean they're above criticism, and that certainly does not mean they're above scrutiny. So all of these judges in these cases who are giving these favorable rulings to these sex trafficking operations, just know that you are on the radar now as well. Because this cannot stand. This cannot stand. We cannot have rulings like this in the United States of America that blatantly disregard the rights of people who have been part of a sex trafficking ring. And it's not like this is conjecture at this point. It's not like there's just, a little bit of evidence pointing this way. Everybody knows that this was occurring. All of these judges know it was occurring. But because of the loopholes in the two-tier justice system, here we are. Enough is enough. We must demand change. We must demand that our elected officials write laws that are equal to everybody. No more of these stupid-ass loopholes. No more of these little by notes written within the law to get their friends off. None of it. Enough is enough, all right? We're not ruled by an aristocracy. We're not ruled by royals in America. I mean, I know they think that they're robber barons and they're ruling over us, but that's not the case. None of us here are subjects, okay? We are all citizens, and it's about time we start acting like it. If you'd like to contact me, you could do that at bobbycapucci@protonmail.com. That's BOBBYCAPUCCI@protonmail.com. You can also find me on Twitter at BOBBY_CAPUCCI. All right, everybody, until later on.